Hi everyone, welcome to this session. Apologies for the delay in getting started. We're having a few technical issues, as you can hear. Hopefully they won't affect us during this session. Our speaker can't see himself on video, but hopefully you can see the slides on the screen. So I'll start by introducing myself and then I'll hand over to our speaker today. So my name is Ibrahim and I'm the IRMS Legal Group Chair. You're being brought this session by the Information Records Management Society, as well as our speaker from Act Now Training. Today's session will be on the topic of the Data Reform Bill impact, and our speaker today will be exploring how the government plans that the impact of the UK GDPR and the PECR. Ibrahim will also analyse some of the latest news and enforcement action from the UK. So if you have any questions, please use the chat function. In the chat function, you'll see two options. You'll see the regular chat, and then you'll see the option to add a question. If you use the question section, that would be excellent, so that we can upvote the questions and push them to the screen for our speaker to answer today. If you have any questions generically, please feel free to use the chat function, or if you'd like to communicate with others at the event today. There are some slides available for this session in PDF format, and if you would like to receive them, you may email Ibrahim. I'll pop his email address in the chat section. Okay, so I think without further ado, I'll hand you over to your speaker today, Ibrahim.
Thank you very much, Iram. Pleasure to be here. Hopefully everybody can hear me and see me and see my slides. As Iram said, I might not be able to see the questions straight away, but feel free to let Iram know and she'll read them out to me. As Iram explained, this is a general update on the GDPR, in particular looking at the reforms proposed by the Data Protection and Communications Bill. Little bit about Act Now Training. We've been in this space for about 20 years now, just celebrating our 20th anniversary. We provide training and consultancy in all aspects of data protection information law. I think most of you will have probably heard of us and have attended our courses and picked up no doubt one of our designer bags from the IRMS stand at the conference. So lovely to see you all anyway today. As I say, I'm going to talk a little bit about enforcement, but really in the majority of the time, I'm going to be looking at the changes proposed by the Communications Bill. Before we do though, I always like to pose a question, and first question from me to you is, who is the odd one out from a data protection perspective? I'm sure you watch Have I Got News For You, so you'll be familiar with this. Who is the odd one out from a data protection perspective? Any thoughts, anyone? See if we have any takers. Penny says it's Trump. Okay, thank you, Penny. Anybody else? Sonia, oh, you can see the slides, that's good. Any other thoughts? Occasionally I might have to sort of zoom out to see what you're saying. I think that's the best way. Any other thoughts? Who is the odd one out?
The guy on the plane, yeah. I don't recognize him.
Okay, the guy on the plane is the chairman of British Airways, Sarah. We're getting there, we're getting close. Okay, I'm gonna keep you guessing, guys. I'm going to reveal the answer at the end. I'm just gonna, it's an incentive to stay till the end, yes. Okay, I'm sure everybody knows this by now. John Edwards, he is the Information Commissioner. You could say the new Information Commissioner, took his post in January of this year. Of course, in charge of not just GDPR, but also Data Protection Act 2018, Freedom of Information Act, and lots of other legislation at his disposal. There's been some concern of late, some writings with regards to the enforcement action taken by the Information Commissioner, in particular, the level of fines and the level of enforcement action generally. It's not just about fines, as he will tell you. He has a whole armory of notices that he can enforce against organisations that are slow in complying with data protection legislation, particularly the UK GDPR. But it's interesting that so far he's only issued 12 fines. His office has only issued 12 fines compared to about, I think Ireland has issued 68. Even much smaller countries have gone well into sort of over 50. Spain, I think over 100 fines have been issued in Spain. Now, recently, you'd think that, well, the Commissioner might do a little bit more in terms of enforcement, particularly as there have been lots of high-profile cases involving a misuse of personal information. But actually, it's the opposite. Recently, just actually a couple of days ago, I was at the NADPO conference, some of you may have attended, and there the keynote was by John Edwards, and he said that fines don't work, particularly when it comes to the public sector. In fact, if you remember in June, he announced that he'd written an open letter to public authorities saying that he would use his discretion to reduce the impact on fines on the public sector. He says, and he said this in the NADPO conference as well, fines don't work against the public sector because, well, the money just goes back into the Treasury and then goes back out to the public authorities again. So he wants to use wider powers, including warnings, reprimands, and enforcement notices, with fines only issued in the most serious cases. At NADPO, he talked about where there's willful sort of neglect of data protection, where there is serious gross misconduct, or where an organization has profited from failing to comply. Now, the question did arise at the NADPO conference. Some people asked, well, why is that specific to just the public sector? What about the private sector? What about the charitable sector? Didn't really wasn't really very convincing in terms of his answer in relation to that. He was more sort of saying that at the moment I'm looking at the public sector, we'll see how it goes. Didn't even commit to using that same discretion when it comes to the voluntary sector, the charitable sector. This approach has recently been applied in the case of the DFE. You may have seen this on the 7th of November, I think it was around that time. The DFE received a formal reprimand for what the Commissioner said was a serious breach of the GDPR involving the unauthorized sharing of information relating to 28 million children's personal data. The Commissioner said that the breach was woeful. It was woeful data protection practice, 28 million children's information. And had it not been for this new discretionary approach, the Commissioner could have issued a fine of up to £10 million, he said. But in this case, he decided to issue a reprimand. He said that the DFE had done what he had asked them to do, and there was no benefit in just taking money out of the public purse, because that will inevitably have an impact on services. So from £10 million to a reprimand. Don't know what you think. Happy to take your views, but I think that in that kind of case, 28 million children's information, 28 million children's information, and it related to the sharing of information by the DFE with initially training providers and education providers so that they can check the ages of children to ensure they're eligible for courses. But that information in the end ended up with a company that was providing age checks for betting and gaming companies. So serious breach, yet only a reprimand. I don't know what you think. Let me know what you think in terms of whether you think that is fair. Another one where he used the discretionary approach, NHS Blood and Transfusion Service. This involved the inadvertent integration of untested development code for a future liver scheme into the NHS's live environment. This integration error led to a number of prospective transplant patients being excluded from the liver matching run, which meant that there was a delay in them having their operations and getting a replacement liver, etc. Again, this was one where you would have thought perhaps there could have been a fine. Commissioner issued a reprimand. Another one which involves the Commissioner's revised approach, the Cabinet Office, you may remember, back in, I think this was the 2020 New Year's Honours List, What happened there? They published the honours list together with the names and addresses of a number of individuals who'd received or were about to receive honours. Not just sort of celebrities, but also ordinary people, lollipop ladies and the like, Holocaust survivors, police officers as well. They published their home addresses. The commissioner initially issued a fine of £500,000, serious data breach, put a number of individuals had to be receive police protection as a result, but then recently there was an appeal, and before the appeal the commissioner decided, well, actually I'm going to reduce the fine, and they reached a settlement whereby it was reduced by £450,000. So it ended up with only a £50,000 fine. Yeah, so this is the commissioner's revised approach. I've got a question from, let's see, from Hillary. In the most serious cases, how serious does it have to be? 28 million children. Absolutely, Hillary. I absolutely agree with you, and so does Carol. Anne, let's have a look. I work in the NHS and know that if we get a fine, it would genuinely impact patient care, but I also think a reprimand would be shrugged off. Yes. Yeah, maybe some charitable work or some that's a good suggestion, and charitable work, some community service perhaps. Yeah. Okay, so I think generally you're agreeing with me that, and if you're the private sector, and I'm sure we've got colleagues here from the private sector, you'll think, well, why the difference? I mean, look at this one, a recent fine, October of this year, £1.35 million, Easy Life, catalogue company. They were found to have used almost 150,000 customers' personal data to predict their medical conditions. What they were doing was that they had records of what people had bought, and then they were using that information to infer that certain individuals had bought certain products, therefore they had a certain medical condition. And therefore they were then using that information to ring them up, to cold call them and say, would you like this medicine? Would you like these supplements? Would you like this disability adaptation or this aid? So they were profiling individuals with a view to ascertaining or guessing their medical condition with a view to selling to them. So not only were they fined under GDPR, but they were also fined under PECR. So different approach when it comes to the private sector. Some would say, or the commissioner would say, this was one where they profited from their failure to comply with the legislation and hence the fine rather than a reprimand. So that's all I'm going to say in terms of enforcement. Interesting decision coming up. TikTok, they have been issued with a notice of intent, not a fine yet, of £27 million. Commissioner investigation found that they had failed to comply with the provisions relating to processing information online about children. We all know that under the age of 13, you need parental consent if you're providing information society services, which is clearly what TikTok is doing. That's a notice of intent. We don't know more than just the fact that possibly they may have breached the new or relatively new Children's Data Protection Code, but we're waiting for the final fine on that, and that'll be interesting. TikTok, obviously one of the most successful companies in recent years, has very deep pockets, so no doubt they will probably appeal that decision anyway. So we'll hopefully get some good learnings from that. I know John Edwards a couple of days ago at the NADPO said that Easy Life were also appealing that decision. So hopefully we'll get some good sort of advice and interpretation from the tribunal. If you want to know more about the fines, I've more or less done a blog post on every single fine issued so far by the commissioner, as well as their revised approach. Have a look at our blog, actnowtraining.wordpress.com. Let's go on. Any questions so far? Any other observations before we move on to look at the Data Protection and Digital Information Bill? Something that we thought was on and then it was off, and then now it seems it's back on again. Yep, such is the exciting lives that we lead as data protection officers. The Data Protection and Digital Information Bill comes as a result of the government's consultation entitled Data: A New Direction from September 2021. It was introduced in Parliament, I think, in July of this year, back in the days when Nadine Dorries, do you remember her? Her from Jungle fame and whatever other reality TV program she's appeared on. Certainly not known for her, well, not famous for her political acumen, let's put it that way, being a big backer of Boris Johnson, wanting him to come back from wherever he was on holiday to lead the Conservative Party once again. But anyway, they got rid of her. And when they did so, they got rid of Liz Truss, and we have a new Secretary of State. But at the time, back in sort of September, we were expecting this bill to make its way through Parliament. It was ready for the second reading. And then what happened? The Conservatives ate their leader. Well, they had two leaders. We have a third leader now within the space of a few months. So she was replaced by another lady, Michelle Donelen, Secretary of State for Digital, Culture, Media and Sport. And she made a big speech in, I think it was in October at the Conservative Party conference, saying that data protection, she wants to go back to the drawing board. She wants to make it more business friendly. She wants to draft it with business in mind and all sorts of other platitudes. And we thought that, oh dear, they're going to completely go back to the drawing board, and they're going to do even more with this bill. And we can all stop writing about it and wait for the new bill to come out after possibly a consultation. That's what we thought. I mean, that was the kind of rip-roaring speech that she made, went down very well with the Conservatives. But then what happens, as usual, ministers make speeches, but then they don't actually follow it through, or the civil servants thinks, well, actually, that's not going to work. So what happened? Initially, they said they were going to go around and do another consultation and maybe redraft the bill, perhaps even look for some new Brexit benefits, if there are any. Now, recently, I was at the IAPP Data Protection and Privacy Conference in Brussels, where they had a gentleman from the DCMS, and he said that, yes, they were going out to consultation, but it's not going to be a full-blown consultation. It's going to be more of a series of round tables with industry, with experts, with a view to seeing if they've not missed any opportunities to make data protection perhaps simpler or make it more business friendly. So there's not going to be a new consultation. I don't think there's going to be a new bill. Series of roundtables, is that really going to make a difference? I'm skeptical. I don't think it's really, they may tinker a little bit more than what they've done, because remember, they made big promises when they went out to consultation. When they published the bill, they said that it was going to create a more pro-growth data regime, whilst maintaining the UK's data protection standards. They said that it was going to reduce barriers to innovation. It was going to boost trade. We're going to deliver better public services, reduce the burdens on business, and better outcomes for people. Well, we're going to have a look at that to see whether, is it actually going to work? Is it going to reduce the burden? Or you might say, actually, the burden, certainly for business, isn't there in the first place. Certainly if you're a small, medium enterprise, then a lot of the provisions that they're talking about getting rid of or simplifying simply don't apply to you anyway. And they promised reform of the Information Commissioner's Office. So let's have a look at that. So the message seemed to be initially, when Michelle Donelen took over, that she would go back to the drawing board and completely redraft it to make it even more business friendly and reduce red tape and produce Brexit benefits. But as I say, I think it's turned, I don't think that's going to happen. A few roundtables, maybe a little bit more tinkering on the edges, but in the end it's going to remain the same. So you have to dig out your notes, you have to dig out the your version of the UK GDPR. Field Fisher Waterhouse have actually, and I might be able to show you, maybe even share the link as well, they've produced a very useful red line version, which I should be able to share with you guys.
There we go. I think we can see it now.
Okay, beautiful.
Oh, we
right.
a minute ago.
Yeah, I popped it into the link into the chat function, so you should be able to see it there. And that sort of tracks the changes that are being proposed, or track them as per the bill as it was drafted in September. Okay, so I'm going to pick out a few sort of key provisions. I mean, obviously in the time available, can't go through everything, but the things that I've found sort of interesting. The first thing is clause, let's look at clause 1 of the bill. I want to look at the definition of personal data. Definition of personal data. Personal data means any information relating to an identified or identifiable living individual. Okay, no change there. Who can be identified directly or indirectly, in particular by reference to an identifier such as name, etc., etc. Okay, no difference there. However, it adds a clause 1A. An individual is identifiable from information directly if the individual can be identified without the use of additional information. Okay, fair enough. But also, an individual is identifiable from information indirectly if the individual can be identified only with the use of additional information. Okay, so this proposed change would limit the assessment of identifiability of data to the controller or processor and persons who are likely to receive the information rather than anyone in the world. So it could make it easier for organizations to achieve data anonymization, as they no longer need to concern themselves with potential future identifiability, with the focus instead being on identifiability at the time of the processing, i.e., when you are processing the information, can you identify the individual directly, or can somebody else at that time identify the individual using other information? So perhaps it will allow you to do more with personal data by saying, well, actually, it's not personal data because nobody can be identified directly from the information, nor can they be identified at this moment in time. If we put the information out there, people would not be able to identify those individuals. Whereas at the moment, even if the information, other information could come to light in the future, which could identify an individual, that would still be personal data. You could argue there's scope there for doing more with personal data. It's arguable. Okay. So that's the definition of personal data. It's a bit of a moot point. Let's look at the next one, which is certainly more interesting, perhaps, which is legitimate interest. Now, within the proposals, they said that they wanted to clarify when an organization can use the legitimate interest grounds. As we know, Article 6, consent is only one way you can justify your processing. The other ground is where processing is necessary, where it's a legitimate interest of the controller or processor, except where such interests are overridden by the fundamental rights and freedoms of the individual. So you have to carry out a balancing exercise. What the government is proposing is adding an extra legitimate interest grounds, so separate to the one involving a balancing exercise, and that would be ground EA, where processing is necessary for the purposes of a recognized legitimate interest. Now, if you're processing for the purpose of a recognized legitimate interest, then you don't need to do the balancing exercise, i.e., you don't need to consider whether it would the impact on the rights and freedoms of the individual. Now, what's a recognized legitimate interest? It tells you in Annex A, where for the purpose of national security, emergencies, crime, safeguarding vulnerable individuals, democratic engagement, and the list goes on. In these cases, you do not need to carry out a balancing exercise, and you can use this additional legitimate interest grounds. So that means you can do more with information. Now, some people would say, well, actually, that already, a lot of that already comes in Article 6 when you look at public functions, public interests, even, and why shouldn't organizations who, where they're doing something in addition, then they should be required to carry out the balancing exercise. But again, it's part of the government they say one of the reasons for these changes is to make things a bit clearer, where there's a clear legitimate interest. You don't need to carry out a balancing exercise, but some would say these are the reasons for processing already built into public functions, public interest, which is set out within Article 6 anyway. Let me know your thoughts. Okay. Let's go on to look at vexatious requests. Again, this is one of those where they say it's business friendly. We're going to make it easier for organizations, for anyone, any data controller, to refuse a data protection subject access request, or indeed it's not restricted to just subject access, it's any request, any of the rights requests. Now at the moment, you can refuse a data subject request where the request is manifestly unfounded or excessive. Okay. Clause 7 of the bill proposes to replace this with vexatious or excessive. My question is, what's the difference? Now, examples given in the bill, and the bill does give examples, are those requests intended to cause distress, not made in good faith, or that are an abuse of process. Why can those examples not fit into manifestly unfounded and excessive, and why do we need this change? Question to you. I mean, anybody think it's exactly the same and we don't really need this change? But again, government wants to tinker to make people, or perhaps for those who think that data protection is difficult, to say that, well, actually we've made it easier, but have they? Have they just changed the terminology? Any thoughts, anyone? Let's see, Sonia's typing. Yes, Sonia, absolutely. There's already an exemption for national security anyway. Possibly to bring it in line with FOI, I'm not quite sure. In terms of the subject access provisions, possibly, but I mean, there's no need to bring it in line with FOI, I would say. I mean, it works manifestly unfounded and excessive. If you read the Commissioner's guidance note on EIR, because that's where they use manifestly unfounded or excessive, they don't, they say it's effectively, the guidance is that it's effectively the same as vexatious and repeated. This is what the Commissioner says. Okay, let's move on then, folks. Let's look at data protection officers then. Goodbye, data protection officers, it says, just to worry you a little bit. But actually, is it really goodbye, data protection officers? Once again, the government has billed this as well. Small and medium organizations, they haven't got the resources to appoint a data protection officer, and it costs too much, and they really need to do this. We're going to make it easier. We're going to cut this red tape. But are they really cutting red tape here? Because initially, well, they've got rid of the requirement for a data protection officer. Yes, they have. However, if you're a public authority, if you're a public body, or you carry out processing, which is high risk of processing, then you need not a data protection officer. They say you have to designate one individual to be a senior responsible individual. A senior responsible individual, if you read the TAS, is another name for a data protection officer. This person, though, has to be part of the senior management team. You can job share, you can have more than one person do this job, but they have to be part of the senior management team. So there's, whilst it's still a doing job, I mean, if you look at Article 27B, the new Article 27B, the tasks of the data protection officer, or the senior responsible individual, SRI, I suppose, would be the acronym, monitoring compliance, ensuring that the controller develops and implements measures to comply with the legislation, informing and advising the data controller, dealing with complaints made to the controller in connection with personal data, cooperating with the commissioner, monitoring compliance, avoiding conflicts of interest, etc., having professional qualifications and knowledge of data protection legislation, etc. In addition, it talks about, strangely, organizing training for employees, good for us, dealing with personal data breaches as well. So it's a hands-on, still a hands-on doing job, but it says they have to be part of the senior management team. Now, that means that obviously those organizations that are using external outsourced data protection officers, I suppose they'll still be able to use that service, but they won't be able to call them their sort of senior responsible individual. That will have to be somebody within the organization, somebody who's part of the senior management team. Okay, let's see. Anne, you've got a question. Does the change from natural person to living individual in the bill on NHS requests for deceased patient records? I don't think it will sort of have an impact, Anne, because obviously it's still about living individuals. So natural persons or living individuals, roughly the same thing, really. When it comes to access to dead patients' records, obviously we know that it's the Access to Health Records Act, and where they're the next of kin or somebody who has a claim arising out of the death of the deceased, or alternatively, they can make an FOI request subject to the duty of confidentiality. And Alice, sorry, is the SRI designed to be similar to the CSIRO? Well, certainly they are a senior person, but the CSIRO, I would have thought that this is more of still very much a hands-on doing job, whereas a CSIRO often sits higher up in the organization and can delegate and has an overall responsibility. That's my understanding. But I mean, there's no reason why you can't have the same person doing the two jobs. It doesn't have to be their only job. Yeah. Okay, so any other thoughts on the role of the data protection officer, the fact that they have to be part of the senior management team, although it does say later on that the individual who is the CSIRO can actually delegate certain tasks as long as there's no conflict of interest. They can delegate the tasks to other individuals. A controller processor must support its senior responsible individual in the performance of their tasks, including by providing the individual with appropriate resources. And of course, it is a protected job, so you can't be sacked for doing your job, for blowing the whistle, for informing the commissioner, etc. So that's the senior responsible officer. Let's move on. See if we have a question. Sonia thinks it's a good thing. Yeah, maybe it will create more of a sort of more importance and give data protection and privacy more importance within the organization when that person sits on the senior management team, whereas at the moment the DPO can take reports to the senior management team, but in the end, say if there's no somebody senior championing the project, championing the provisions, then sometimes it falls by the wayside. So yeah, I agree. If they delegate, they can delegate certain tasks to the to other individuals who may have better qualifications, Alice, but those individuals are not in protected jobs, no. Arguable, and it depends on the project or the advice that they're giving or what they're involved in, because if they're, say, for example, involved in a new project, a new initiative, and then they also have to consider reporting data breaches in relation to that, or doing a DPIA or advising on a DPIA, then there could be a conflict of interest. I think you have to look at it on a case-by-case basis, but the more senior they are, the more sort of they tend to have their sort of fingers in many pies, and there's more likelihood of a conflict of interest. Yeah. Okay, checking the time then. Rethinking DPIAs and rethinking ROPPers. Okay, let's have a look at those. At the moment, organizations have to do a record of processing activity. As well as obviously in some cases you have to do DPIAs. Clause 15 of the bill proposes to replace it, the ROPPer, with a leaner record of processing personal data. Clause 17, let's have a quick look. basically there will be fewer things that you will have to include within the ROPA, so it makes the job slightly easier. Of course, we know that if you have less than a certain number of employees, then you don't need to do a ROPA anyway. Here we go. So a lot of the provisions, a lot of the things that you have to do, name and contact details of the controller, the description of categories of data, where you're going to transfer data to, the time limits for the different types of categories, technical and organizational measures, all those have been taken out of the requirement for a ROPA. So your ROPA does not include those provisions. However, you still have to include how long you intend to retain the data, whether there's any special category data in there, whether there's any criminal conviction data in there, information about how you're going to keep it secure, and obviously there's a requirement, similar requirements in terms of data processors. So it makes the job slightly simpler, but some would say, well, what we have at the moment in terms of Article 30 and the ROPA is good because it makes an organization think about the kind of data that they hold. It gives them a data inventory, a sort of a data audit ready-made in an Excel spreadsheet. So why tinker with that? It does help compliance, but once again, government seems fit to sort of change it. In terms of DPIAs as well, they are proposing to make the job slightly easier, leaner, less prescriptive assessment. It's not a DPIA anymore. It will be an assessment of high-risk processing. Clause 18 ensures that controllers are no longer required under Article 36 to consult the ICO on certain high-risk DPIAs. So you have to ensure by doing the high-risk, it's an assessment of high-risk processing, not a DPIA anymore. And the requirements in terms of what you have to record are leaner, and perhaps the good news is that you do not have to consult the commissioner. But then those who did consult the commissioner hopefully will have received good advice about how to reduce the risk of the processing, the new project, the new initiative, because of course the whole idea with a DPIA, it's a risk assessment. And if you find that the risk is still high, the idea with consulting the commissioner is you get good advice about reducing the risk. Of course, they can always tell you not to process the data in the first place or go back to the drawing board, but that was the idea. Now there's no requirement to consult the commissioner. Okay, any thoughts on that one? Sonia, mixed feelings about the ROPA. On the one hand, it can be quite burdensome, but found it, yeah, absolutely. Thank you, Sonia. Okay, let's see, one more then. In terms of data subjects complaints, now at the moment, there is no requirement for an individual to make an internal complaint before they complain to the Information Commissioner. They could go directly. Nothing expressly requires them to complain, unlike FOI, where the Commissioner will not get involved until the individual has, they've exhausted your internal complaints procedure. Clause 39, as it is proposed, would make provision for this and require the controller to acknowledge a receipt of such a complaint within 30 days and respond substantively without undue delay. But under 40, if a subject has not made a complaint to the controller, the ICO is not entitled to accept the complaint. So in a way, that will mean fewer complaints to the Information Commissioner, which is good news for them, but also I think it's a good news for you in terms of being able to redress and being able to put things right before the official complaint to the Commissioner, because those of you who've had complaints to the Commissioner, even if they're unfounded, they do take a lot of time and resources to deal with. Finally, in terms of changes, there will be a new Information Commission as opposed to an Information Commissioner's Office. Yes, slight change there. So instead of the Information Commissioner, we will have an Information Commission with a new Chief Executive. I suspect that will be John Edwards, the Commissioner, and they have sort of retitled and sort of repurposed the role of the Commissioner. So now they are saying there should be a focus not just in terms of not just in terms of the Commissioner's privacy sort of enforcement, but also a statutory framework setting up strategic objectives, having to have regard to economic growth, innovation, and competition issues as well. So they're changing the emphasis from just being a purely privacy regulator to having regard to business to competition. So making it more business friendly and making the Commissioner think about the impact on business in terms of what they do and how they enforce the legislation. So let's see how that will work out in terms of the Commissioner's sort of interpretation of the legislation as well, and future enforcement action. Something else which is interesting, which has been proposed, is a new right of access by customers to business data. Those of you who are particularly in the private sector will find this interesting. There's not much meat on the bones at the moment. The bill just gives the Secretary of State the power to issue regulations requiring data holders to make customer data and business data available to customers or third parties. Okay, so regulations we're expecting. Customers would not just be data subjects, but even business would be able to ask other businesses for information about goods or services that they've purchased, digital content, other sort of services that they have provided. It would also include information about where those goods are supplied, the terms on which they are supplied, prices, performance, information relating to feedback from customers. So this has the potential to be sort of FOI for business. People should be able to get hold of more information about business, their performance, their feedback, and also their own usage patterns as well. Now, some of you may think, well, what about the right to portability? But this has the potential to guarantee provision of data in real time, and not just data as in under portability. Only an individual only has a right to port data over which they have supplied to the data controller. Here it's much wider. So that will be an interesting one, and we'll see what happens with that, and whether in their drive to make this even more business friendly, they might even drop those provisions. Okay, so what's the impact going to be of these changes in terms of adequacy? Well, I'll let you think about that. Do you think they are fundamental changes, or do you think there's just a bit of tinkering around the edges? Will there be two regimes for some? Because obviously we've got the EU GDPR, and if you are processing the data of EU residents, offering them goods or services, monitoring their behavior, you still have to comply with the EU version, where you may need a data protection officer, you will need to do a DPIA, you'll need to do a detailed ROPA. Some of the Article 6 changes won't be available to you. Do you think it's less red tape, or and what's missing? Any thoughts, anyone? Questions, queries, comments, or concerns? Happy to take them.
We do have a question actually in the question section, not particularly related to this, but
okay.
Craig asked a question. So business data, presumably this would also affect local authority traded services.
Quite possibly. I haven't really, as I say, it's quite sort of sparse, the detail, but we'll wait for regulations, but it may well do, I would say, may well do. At the moment, it just talks about sort of business in the sort of wider context, but I think we'll have to wait for the regulations in terms of the definition. But if they're clearly, certainly local authorities have set up arm's length companies, companies limited by guarantee, etc., and their trading services, I suspect they will come into that. Sort of more internal traded services, we'll have to wait and see.
Thank you.
Okay, what's missing then, folks? Let's very briefly, whilst we've still got a little bit of time, what's missing? If you remember back in last year, when they had made these proposals and they were consulting, the government made a big thing about changing the accountability framework. The sort of requirements about ROPAs and DPIAs and DPOs. They did talk about changing the requirement to report data breaches, but they haven't done that. But they said that they wanted to come up with a new accountability framework in the form of requiring organizations, they would get rid of these provisions, ROPAs, DPIs, DPOs, etc., but replace them with the requirement for a privacy management framework. As it says there, this proposal would require an organization to develop and implement a risk-based privacy management program that reflects the volume and sensitivity of the information and the type of processing. This would include appropriate policies and processes for the protection of personal information. So they were talking about replacing what they're still going to replace or whittle down with the requirement to do a privacy management framework. So it's not that you get rid of DPIAs, DPOs, etc., but you don't do anything. You have to produce a privacy management framework. So you decide how you're going to implement the legislation and how you're going to comply, bearing in mind the volume and sensitivity. So it's sort of more of a more personalized approach to data protection. It would include, or should include, it said at the time, roles and responsibilities, oversight and support from senior management, demonstrating how the organization is complying, plans and processes to monitor, assess, review, etc., etc. So there were certain things that you needed to do and needed to come up with as part of your privacy management framework. They seem to have got rid of all that. There's no mention of that within the bill. So who knows, maybe they're going to bring that back as part of this new consultation, these new roundtables that they're going to be conducting. If you do get an invite to a round table, whether it's round or otherwise, do let me know and do spill the beans as to what was discussed. Yep, so let us know. But at the moment, there's no talk of this privacy management framework. Still a good idea if they're going to get rid of some of the other provisions, and this might be something that you might want to do internally. So just let's see what happens with that. Finally then, PECR and marketing, not going to say too much about this. There are proposals to change this as well within the bill. They will change the cookie rules, so make it easy. Well, what are the rules at the moment? At the moment, cookies, other than those which are strictly necessary, you need opt-in consent. And we all know the problem with cookie banners and all that. Yeah, won't go there. Subscribers must give prior consent to cookies being placed or used unless they are strictly necessary. The government is proposing to change this within the bill, removing the consent requirements for analytics cookies and similar technologies, because the Commissioner's view is that analytics cookies are not strictly necessary. Therefore, you do need a opt-in consent, even if just for Google Analytics. So they're going to remove that. So analytics will be fine. In future, moving to an opt-out model of consent for all cookies placed on websites other than those likely to be accessed by children. This will be a significant change, provided that the website gives the web user clear information about how to opt out. And it'll also require websites to respect individuals' privacy settings as set out through their browser. Something else that they're proposing within the bill is to extend the soft option opt-in to political parties, charities, and other non-for-profits. As you know, when it comes to email and text messages, an individual who hasn't consented to marketing, but they have previously been involved in a sale or negotiations for a sale, you gather their information and you give them the chance to opt out at the time, and in every message, then you can market to them. This is known as the soft opt-in. But it's only available for commercial services. They're going to extend that to political parties, obviously, because they have a vested interest in that, to charities and other not-for-profits. And one of the biggest change probably is the fact that they propose to increase the level of fines under PECR. At the moment, it's £500,000. They're going to extend that to 7.5% and 4% of gross annual turnover, the GDPR levels effectively. I mentioned the reform of the Commissioner. If you want to know more about the bill, I've done a summary. It's on our blog. And of course, you'll be able to grab a copy of the slides. If you want to just send me an email, I can do that. Let's just have a look at some questions then. Sonia, moving to an opt-out model for cookies is in direct opposition to DPIA consent requirements. Yes, But remember, if they are using cookies in order to gather personal information, then the opt-out won't work, because then they are processing personal data, and therefore they would need opt-in consent as per GDPR. But remember, cookies aren't just used to, often they're not used to gather personal data. They're more about what device you are using, which browser you are using. So technically it's not personal data unless it can be linked to you as an individual. That's where the opt-out model will work. But you're absolutely right, Sonia. If it involves personal data, then GDPR obviously trumps PECR. Any other questions, folks? Whilst you think of some questions, let me quickly plug our website, actnow.org.uk. Lots of other, obviously, articles, but of course, courses as well. We do lots of detailed as well as general courses on GDPR, as well as freedom of information, records management, and cyber security. Those of you who've done our GDPR practitioner certificate, I know many of you have, have a look at our advanced certificate in GDPR practice. This is a 3-day advanced course, 1 day per month, because it's like a university tutorial. So it involves 3 masterclasses, and you have to do some very detailed work on some detailed case studies and prepare your answers. And then you come along to the masterclass where you discuss, you argue, and you try and come up with the best answer as a group. So that's one of our most popular certificate courses at the moment, really for experienced data protection officers who know their beans, but they want to take their skills and their knowledge to the next level. And finally, a plug for our the data protection IG apprenticeship. If you want to encourage new people into the profession and get them trained using government money, of course, then this is the new apprenticeship which was launched very recently. We're working with one of the big providers, Daymar Training. We're providing the sort of training and the materials for this apprenticeship, and it's very, very popular. We've taken on 40 apprentices so far with Daymar, and we've got another 40 starting in January. So that's something that's quite useful, especially, as I say, we want to encourage new people into our exciting profession that we know it is. So something to have a look at that as well. Okay, folks, any last questions before I put you out of your misery in terms of the odd one out round?
Yep, just one from Anne.
Okay, Anne, yes, from your experience attending Brussels, do you see what do you see as the implication for UK continued adequacy? I think the way it is drafted at the moment, this bill, and I don't think we've got anything to worry about in terms of adequacy. They promised the earth in terms of their speeches and what they were going to do and cut red tape and get rid of the difficult bits, etc. But they haven't really. They've just tinkered around the edges, and I don't think that it's going to have an impact on adequacy. If they go for more fundamental changes, then I think there will be an impact. I mean, one thing I didn't mention was that of course, the UK can now make its own adequacy decisions, and recently they have made a decision, I think, was it yesterday, in relation to South Korea. Hooray, we're going to make about £17 million a year out of that as an economy. But they have the right to make their own decisions, and one of the changes is that they will assess countries not based on their data protection laws as to whether they are equivalent, but they are overall whether the standard meets our standards. So it's a slightly lower test than perhaps the EU. But I mean, the bottom line is I don't think it's going to make a difference. I think adequacy, in the end, a political solution will be sought. The EU is still our biggest trading partner, and they're not going to throw away our relationship, even though, well, some would say Brexit means that we have. But so, yeah, I don't think it's going to have an impact, personally. Okay, any other questions? Sorry, Ibrahim, fire away.
That's okay. There's 2 in the questions section, so I will start the live answer on the first one. So where do you feel the retained EU law revocation bill coming in with the sunset clause of the 31st of December 2023 comes into play with DP and PECR reform? And where do you think this all leaves the UK's adequacy?
Yeah. As I said, in terms of the retained, this so-called bonfire of Brexit regulations, my understanding is that the UK GDPR is it's now enshrined within UK law. And I think what they will, at the most, what they'll have to do is bring in some, it's not something that they're going to get rid of. Certainly some of the sort of other regulations with regard to the colour of strawberries or the size of pears or the curvature of bananas, etc. That's where, you know, they'll let them wane. But when it comes to the GDPR and PECR, etc., I don't think it's going to make a difference. I think it's already enshrined within UK law, but even if it's not, they'll bring in a statutory instrument to say this is staying. It's not. They're not going to get rid of this. As far as the again with regards to adequacy, I haven't seen anything fundamental within the bill which suggests that our adequacy is in danger at all. If they started tinkering with the rights, getting rid of some of the rights, getting rid of the requirement for privacy policies, for transparency, for reporting personal data breaches, things which are fundamental to GDPR, then I think we'd be in trouble, but they're not going to do that. And remember, the GDPR, EU and UK, is the gold standard across the world. We've done work in the States in terms of the CCPA in California. We're doing a bit of work in the Middle East as well. Dubai has its data protection, or Saudi Arabia. It's all very much based on GDPR. They're all copying us. So why should we then get rid of something which is now increasingly the international standard? And they're doing it because it's business, because it will attract investment. It will mean that businesses have the level playing field that they want in order to carry out their activities.
Thank you. And next question, are there any further requirements or changes on international transfers, risk assessments, etc.?
No changes, but do have a look at the Information Commissioner's recent, I think it was published, was it this week or last week, their guidance on the international data transfer agreement, and how you actually carry out a risk assessment. So that's quite useful. We're still waiting for a clause by clause guide, but that makes it slightly easier in terms of doing these risk assessments for international transfers. And also watch out for, I think, IAAP or elsewhere, I heard that we are expecting a transatlantic replacement to the Privacy Shield probably in May or in spring of next year. They're already putting the motions in place, so we will get, Privacy Shield 3.0 or whatever it's going to be called, unless, of course, Max Schrems no doubt will want to challenge that one as well.
Thank you.
Okay.
That's all for questions.
Brilliant. Okay, well, finally then, let me put you out of your misery. Which is the odd one out from a data protection perspective? Well, think about fines that have been issued, not just in the UK, but across Europe. And then you will have the answer. Who has not, or whose organization or company or has not been fined under the GDPR or the UK or EU, it doesn't matter. Under GDPR generally, who's not been fined? Let's see, have we got an answer? Trump, says Catherine. Absolutely, yes. Catherine's got the right answer. Trump, he's not been fined for under GDPR. That's one piece of legislation which I don't think he has been proved to have broken. No doubt there are many other pieces of legislation in the States, no doubt, that we will hear of very soon, thanks to the Supreme Court have said that we can look at his tax returns, see how much tax he's paid, and no doubt that's going to run and run. If it stops him running, then that's all good, I say. So yes, it's Trump. Meta has been fined. I think it's by the Irish Commissioner as well as in Europe as well. Jeff Bezos, obviously that's Amazon, have been substantial fine issued. I think it was Spain or Germany in terms of what they do with algorithms and everything else. And British Airways, of course, fined by the UK Information Commissioner. Okay, thank you very much, folks, for listening and taking part. There's my email address. I think Ibrahim's already shared it, so happy to share the slides with you and any other links that I have, useful documents. Happy to share those with you. Thank you very much for listening, and thank you for Ibrahim for organising this.
Thank you so much. It was super informative. We had a lot of comments and questions in the chat. If anyone wants to continue that discussion, please feel free to reach out to me or Ibrahim. You have his email address in the chat and on the slide here. You can also find it in the registration link. This session is being recorded. As soon as it ends, in a few seconds, it will be available to rewatch via the same link, and it will also be uploaded to the IRMS YouTube channel. So please watch out for that. Thank you all again for taking part in this session. Have a lovely rest of the day. Thank you, Ibrahim.
Thank you.
Take care.
Take care. Bye.
Bye.